So, hi class. Good morning to everyone. And is there who who texted in the group? I forgot the name of the person who asked me about the VNA codification. Is he here?
Yes, ma'am, I had asked Pooja here.
Okay, okay. You asked for VNA codification, right? So there is some network issues at my end today. So I'll close my video and I don't have PPT to share. So we'll continue with the audio only. Also, today we'll be dealing with VNA codification plus assignment and licensing of trademark. So keep a notebook with you, and wherever you feel necessary, please write down, because today we'll be finishing off with the trademark portion, the trademark module, and then in the next class we'll start with copyright. So yeah, so VNA codification. So first of all, when there is a status in the trademark application which states sent to Vienna codification. In that, the applicant or the attorney doesn't have to do anything. First thing, because it is the work of the trademark registry and not the applicant. So, what is Vienna codification? It has 29 categories of trademarks, like which states that there it's a common classification for figurative elements. So if you go through Vienna Agreement, it in the first article itself, it states that it is a common classification for figurative elements. What are the figurative elements? It means that it applies to trademarks which includes symbols, elements, shapes, colors, or any kinds of logos or designs. So except word mark. So it doesn't apply on word mark. I told you what is a word mark, which just it's a combination of words or numbers, but it doesn't include a device mark, right? So device mark is anything which is shape or symbol or color or say design or anything, any like combination of these elements is a device mark. So when you apply for a device mark, so and your logo or your device shows any figurative element in it, the Vienna codification applies to it. All right. So the purpose is to avoid the duplication of registered marks. So just for example, uh, you must have seen the sign of Pidilite. It has this sun in the rising sun in the background, or some element of elephant in it. So what happens is when you file such a logo, the trademark registry searches into the Vienna codification, which uh, like under which clause or under which category the rising sun part exists. So they assign that number to that particular application. All right. So some categories, for example, are some celestial planets, stars, or moons, or sun, or animals. If there is some existence of animal in the logo, or plant, or supernatural creature like vampires and all, and then some scenery, food items, or colors, or geometrical designs. So all these cases, so there are 29 categories, and also there are subcategories of those categories. Okay, so if you go on the website of WIPO, or you just type on Google Vienna codification under WIPO, so you'll get first or second link, wherein if you click on that link, it will take you to a page where two PDFs are given, one in English, one is in French. So you go to the English PDF, and then you will see that those 29 categories are numbered and they are given, and uh, but it's not the work of the applicant, so you don't need to worry about it. So whenever you file an application with a logo, the first thing which the registry does is they send it to Vienna codification. That's why the status shows as send to Vienna codification. So it is written send, but technically it should be sent, because uh, because applicant doesn't have to do anything about it. Okay. So as soon as you file the application, it goes for first the Vienna codification numbering, and then it comes to the formality check procedure for the examination phase. All right. So that is about Vienna codification. I hope you understood it.
Yes,
Is
ma'am.
that clear? Yeah, Pooja. So any doubt about it?
No, ma'am, it's clear. Thank you.
Okay. Okay, then we'll start with the licensing of trademark. So, once the trademark is granted, so till now we have studied about the registration process, and the how the opposition works, how what are the forms you need to file, and how the trademark gets registered. All the phases we have discussed. But once the trademark is registered, it is granted now in practice. So how does a proprietor commercialize on it or monetize or expand his revenue on that trademark? So what are the ways of authorization and monetization? All right, so we'll study about that. So there are two ways. One is assignment and one is license. First, we'll study about license, and then we'll proceed towards assignment. So section 48 to 55 and 136 read with rule 86 to 96 of trademarks rules 2017. Okay, so you can write it down in your notebook. I'll repeat again. Section 48 to 55, 136 read with rule 86 to 96. Do you want me to repeat again? Okay, I guess then everyone has written. So these sections relate to, okay, somebody's trying to repeat. Soumya. So I'll write it down in the chat box. Wait. So I've written that in chat box. Can you see? Okay. So these sections and rules relate to trademark licensing. So what is trademark licensing? It is a method by which trademark owner grants permission or authorization to another party. Okay, so that they can use the trademark on mutually agreed terms and conditions. Okay, so the trademark owner is called licensor here, and the person to whom the license has been given is called licensee. All right, just like you must have read in uh, Transfer of Property Act and all. So here also, and mm, similar terminology is used in contract and transfer of property. So licensor and licensee. So the licensor grants permission to the licensee to use the trademark. So uh, there is a catch that it might probably destroy the purpose of trademark, which is to indicate source and quality of the product, right? So what does licensing like the licensing will affect the purpose of trademark, that why the IP is used, why is any IP like trademark or copyright or patents, what is the purpose? To grant the exclusivity, to show that this particular product or service belongs to this particular proprietor or author or uh, like say inventor. So the basic purpose will get defeated here if somebody licenses. But on another side, on the flip side of the coin, if we see, licensing is again important to expand your business, to expand your revenues, to like you if you start a business, okay, and now you know how to make the product, how to package the product, how to like what are the specific qualities that your product has, but then you don't know how to distribute it, you don't know how to advertise it. So what do you have to do? You will have to hire, or you will have to allot a person your products to distribute it. That's called distribution agreement, right? So in that case also you will have to license your trademark to the distributor so that the distributor could use that trademark. This is also a licensing setup. All right. So for any business to expand, there is a need to license. If you're doing on it on like say a small level and you don't need these kind of licensing agreements, that is fine. But then again, if you want to grow, you want to expand your business into this country or some country abroad or into another state also, then also you will need to license it to someone, because how can a single person manage everything, right? So that is the basic purpose of licensing. But because everything has a two sides to it, so the basic intent of IP also gets defeated somewhere. But then again, we will look at a side which is more profitable to us, right? So under section uh, yeah, one thing more. So licensor has the right to control the quality and nature of goods and services associated with the trademark. All right. So this is a clause in the licensing agreement where the checks and balances is maintained. All right. So let's suppose that I sell my product in a specific way. I package my product in a specific color, in a specific packaging, and then I license it to someone to distribute it. Now that distributor, what he is doing, instead of using pink color, he is using blue color on my products, which is not my identity, not my liking, not my it does not depict what I want to sell. So in that case, I can control the licensing agreement. I can control the distributor to distribute the goods in a particular way. This is called checks and balances in the licensing agreement, wherein the licensor can control the quality and nature of goods. All right. So you need to remember this clause because it is very important when you make a licensing agreement. Now, why is licensee permitted to use? Because it is backed by the section 21R. I'll write it down in the chat box again. Is somebody saying something? No. Okay. So 21R states about the permitted use. Okay. So any registered user can use the trademark, and it is backed by section 2. All right. So that is that. Now, yeah, so I've already explained you about the example. Okay. So now the licensing agreement is not absolute. What do I mean by that? There are now in licensing, the basic difference between a licensing agreement and an assignment is that licensing is done for a limited conditions, and there is no transfer of ownership in the license. Okay, but in assignment there is transfer of ownership. So you need to remember the term or transfer of ownership. All right. So licensing, no transfer of ownership. Assignment, transfer of ownership. Now, when there is no transfer of ownership in the license, but there are transfer of limited rights, and the licensor has the right to put up the conditions or obligation on the licensee to maintain. So I've given you the example, like I want my product to be sold in a specific manner, in a specific packaging. Now, if the licensee is not living up to my standards, now what I will do, I can enforce the rights I can enforce my rights as the owner of that trademark, as the owner of those products, and I can say that under our licensing agreement, these particular conditions are being put. Now you have to follow them. So that is that. So that's how licensing agreement works. So there is transfer of limited rights, okay, with conditions. So there has to be a written agreement. The oral agreement cannot be legitimate in licensing agreement, okay, and it has to be signed so that it could be legally enforceable, and both parties have to adhere to the conditions. Now uh, there are some conditions in the licensing agreement wherein licensor also has to licensor cannot do as he wants. Okay, so if there is a licensing agreement, both parties are bound by it. So whatever the terms and conditions, they both agree on. Okay, so now we'll deal with types of trademark licenses. So basically, there are what I have prepared here are 4 types of licensing agreement. First one is distributor agreement. Write in the chat, distributor agreement. And the second one is franchising agreement. Is there वो है क्या यहाँ पे क्या बोलते हैं उसको board or something? There is a whiteboard or something na in this Zoom meeting. You have to install some app for it. And the third one is merchandise. This one is co-brand. So you can look into the chat box. I've written 4 types of trademark licenses. First one is distributor agreement. Second, we'll talk about franchise. Third, we'll talk about merchandise. Then the fourth, we'll talk about co-branding. Now, what is distributor agreement? Same example. If you are able to manufacture a product, but you don't know how to distribute it, then the distributor agreements need to be made. And so that the your products or maybe something, whatever you are dealing with, can be sold. Okay, so I'll give you a real life example. So have you heard about veg non-veg store, veg non-veg website? Has anyone heard about it? Veg non-veg? Anyone? I've written in the chat box. Have you heard about this website? No? Okay. So there is a website, Veg Non-Veg, which has entered into licensing agreement with shoe brands, international shoe brands like Nike or Puma or Adidas, etc., to sell their shoes on their website. So what they do is they import the limited edition sneakers and everything, and then they sell it on their website within India. Okay, so you can Google it and you can just check. There's this website, Veg Non-Veg. So what does Veg Non-Veg here is? They are distributors, and they have taken license, trademark license from the which owners like Puma, Nike, Adidas. So they have taken the trademark license from them, and now they are distributing it amongst the Indian population. Okay, so that is our example of distributor agreement. Now we'll proceed towards franchising agreement. So you know what is a franchise? So nowadays franchising business, everyone is very interested in taking, but then again they provide they have so many like filters, no, not filters, but conditions, let's say conditions to be followed for entering into franchising agreement with the well-known brands. So let's say you live in a small city and Reliance Trends has opened in your city. So, or let's say Zara has come to your city. So, what is that? Now, somebody from your locality or your city has gotten into the franchisee agreement with Zara to open their store in your city. All right. So that is franchising. Now, let's take example of restaurant. So Virat Kohli ka restaurant, 1-8 commune. You must be knowing about it. You must have heard 1-8. Or let's take a basic example, Starbucks. Now, Starbucks has come to your city. You have taken you have entered into an agreement, a licensing agreement with Starbucks that will open your store here. They have mentioned these particular conditions that you have to follow into the agreement. And if you follow them, you adhere to them, you can open the store. So apart from trademark, what you are getting into the licensing agreement is business know-how, the procedures. So all these also get licensed along with the trademark, because you need to maintain that quality, that taste of the product, the quality of that product. So everything they'll then transfer to you. Sorry. Sorry. So yeah. So why does that happen? Because now with Starbucks, the consumer will identify the same quality of service, right? So you need to maintain that, and they have to transfer that into the license through the licensing agreement. Okay. Now proceeding towards the third type of license. So are you understanding what I'm telling you right now, or just listening like that? Did you understand till here?
Yes, ma'am.
Okay. Except Pooja, can anyone reply? Are you understand? Are you able to understand? Sai, Mathu, Praveena, Soumya, Akriti, Rajesh, Sushma, Priya. So, are you guys there here? Like, are you attending the class? Okay, Soumya. Should I go a little slow so that you can understand? I'm sorry, I cannot prepare the PPT because I was busy. Uh, that's why I'm writing into the chat box. But do you want me to repeat something, or do you want me to go slow so that you are able to understand better? Okay. So anybody else who didn't understand what I've taught till now? I'm going a little faster because we have to complete licensing and assignment both in another half an hour, so that I could leave you early. But if you didn't understand anything, please ask me right now, because after this class, we'll be closing the trademark module and we'll switching out to the copyright part. Anything? So for you, Soumya, I'll repeat once. So I've already told you what is a license. Okay, so suppose Soumya, you are a trademark owner and you have to expand your business. Now you want someone to assist you to uh, so that you can generate more revenue. Okay, so what you will do, you'll enter into a licensing agreement with the second party, and you'll that party will be known as assignee. Sorry, I'm so sorry, licensee. Okay, so you'll enter into the agreement with licensee, and then you will authorize him to use your trademark. Okay, so that is what is called license. What basic meaning of license. And then you have certain rights, and other person also has certain rights and duties towards that writing licensing agreement with respect to your trademark. Okay. So I've told you, I've explained you two types of licensing right now. One is distributor agreement, wherein if you are a trademark owner and you want to, let's say you are, let's just suppose you are selling your products into Kolkata. Now you want to expand your business to, let's say, Mumbai. Okay. So now what you will do, you will find some distributor there, or you will find uh, no, I'll take example of distributor within Kolkata right now. You just forget the previous example. Let's say you are a business person, you have developed a product, you want to sell that. Suppose you have developed a shoes. Okay. Now you have designed some shoes and you want to sell them, but you don't know how to distribute them into the market. So you'll need a distributor. You enter into a licensing agreement with the distributor and you will tell them that you can use I authorize you to use my trademark and we'll share the profits. Let's say that whatever will be the revenue generated, I'll get 30%, 40% of that revenue and you sell my products. Okay. So that is a type of licensing agreement which is known as distributor agreement. Someone distributes your product. Now, what is franchising? The second agreement is franchising agreement, wherein you want to let's take the first example. You want to set up a business in Mumbai, and you presently are living in Kolkata. So for that, you will authorize some person in Mumbai. You will through a franchising agreement to open a store in Mumbai. Okay, so that is franchising. Now you will let's suppose that Starbucks wants to open their store in, give me a city name, let's say Ranchi or Bhopal. Okay, so what they'll do, they'll authorize someone in Bhopal to open a store of Starbucks, and with that, with not only trademark, but also know how the procedures, the ingredients they use in the coffee or their other confectionery products, all of that they'll tell or they'll license it to that particular person in Bhopal. So that is a franchising agreement. Okay. So why is everything told? Because they have to maintain the same quality with the which the original Starbucks is maintaining. Otherwise, the consumer won't return to the store, right? So that is the second type of agreement. Now the third is produce merchandise. So merchandise here means, let's say Marvel. You all watch Marvel movies. ठीक है, अब Captain America है, then there is Iron Man or some other fictional characters. So you find toys and comic books or some other games which are related, which are based on those superheroes, right? So you must have, I'm sure you must have heard about Bewakoof.com. They sell t-shirts there. So what does Bewakoof do? They print the Marvel portraits on their t-shirts. So how can they print that? They have to first enter into a licensing agreement with Marvel. They have to ask that can we merchandise on those like superhero fictional characters, right? So for that, there is a licensing agreement wherein some royalty, some consideration is given to the Marvel production, and then the Bewakoof, the platforms like Bewakoof.com or say Hamleys. Hamleys also sell toys made on the superheroes. So they enter into a licensing agreement with Marvel, and then after the authorization, they can produce such goods. Okay, so that is merchandise. Then the fourth one is co-branding. Co-branding is where two or more reputed trademarks join together in one product, creating a new appeal to same clientele or break into new market. So for example, if somebody is a fan of fashion industry, you must have noticed that Sabyasachi and H&M entered into an agreement wherein they launched a new collection. So that is called co-branding. Okay. Or let's take a very simple example, Maruti Suzuki, Hero Honda. These are also co-branded. So these are different, like separate entities, but like before, sometime previously, they joined in together like in joint venture. Also with that, they co-branded. Okay. So they joined their names, their reputation, and then sold the products with their brand names. Okay, merged together. So that is co-branding. All right. Are these four clear to you? Soumya, was I able to clear your doubts? Okay. So what are the benefits of licensing? So first one is the basic one, the monetary benefit. All right. So both the parties here involved, the licensor and licensee, are getting monetary benefits out of the licensing agreement. The second is the licensor is benefited due to expansion of the business. Okay. So he'll have his products will have better reach. Okay. And the licensee will benefit from the profit sharing. Okay. Now, because I don't have PPT, that's why merchandise. Okay. So under merchandise, what happens? One person, suppose one company, one brand has a big reputation. Let's say Marvel. Now, Marvel is a famous brand, well-known brand, and they have a reputation in making superhero movies. Now, someone wants to sell toys of those superheroes. Now, what they'll do, they'll enter. They are merchandising upon those superhero or those fictional characters. So that is called merchandise. Okay, like um monetizing or say advertising the uh, movie characters with the help of toys or prints or something like that. So here also both the parties are benefited. The Marvel is also benefited because then people are now more interested, more curious to purchase those products, those toys. The like people of our generation or the newer generation, the small kids, they want to buy those superhero toys. So what is this uh, doing in like result? What result is it giving? The Marvel is also becoming more popular day by day. And then the person, the licensee who is selling the toys is also getting benefit out of that revenue from selling the toys. Okay. So both the parties are benefited and you are merchandising upon those characters. So that is how you are expanding their businesses as well as your business. Okay. So it's not like merchandising is not like you are taking the product from the licensor and selling it like in the distributor agreement. What happened in the distributor agreement? You took the product from the licensor and sold it into the market, distributed into the market. But merchandising is different. In merchandising, you see, Barbie movie got released a few weeks back. So what happened? Suddenly there was a rise in selling of pink tops, pink jewelry, like pink toys, and the Barbie toys. So what happened? The movie got released, but then every other person was merchandising upon that movie. They were expanding their business on their movie. So if someone is manufacturing Barbie toys, okay, the Barbie model. So what they have to do, they first have to get a get into a licensing agreement, they have to take authorization from the makers of Barbie movie that we want to manufacture a toy which looks alike Barbie, just like Barbie. So for that, we want your license, we want your authorization so that we could manufacture those toys. So that is merchandise. Is that clear, Soumya? Okay. So we were on the benefits of licensing. First one is monetary benefit. I'm telling you in points so that you could write it down. And because I don't have PPT, that's why I want you to write it down in small points. So first benefit that I'll repeat again. First one is monetary benefit. The second one is licensors benefit due to expansion of business, and licensees benefit due to profit sharing. That is the second point. The third point is trademark brand recognition in other territories. So through licensing, once you have expanded your business, it gets into other territories and then gets recognized by other consumers as well. So that is the third benefit. Okay, brand recognition. And the fourth one is overall increase in trademark popularity. So as the consumers or the customers, see, these are full sentences or statements. So Soumya, writing in the chat box is a little difficult. Wherever there are small points, I'll write it down. Okay. So benefits are general. You could understand that once you enter into licensing agreement, everything is done for money. पैसा 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 है तो सब कुछ है. Okay, so if there is no benefit to the licensor or licensee, no one will get into licensing agreement. So just uh, we can also understand this through basic common sense, that what are the benefits of licensing. One is monetizing, the second one is expansion of business, the third one is recognition, and the fourth one is overall popularity. Okay, so as your business expands, your business gets popular, your goodwill starts building up, right? So that is the benefit of licensing. Now, what are the terms and conditions that you need to remember during the licensing arrangement is first the exclusivity. So exclusivity here means suppose I am a licensor and you are a licensee. Now the licensee wants that I should be able to sell this particular product uh, into Rajasthan. Okay. Now he has put a territorial limit. So he will, and if the licensor, suppose I get convinced, I get agreed to the term that this particular you as a licensee will be granted license exclusive right to sell my product into the territory of Rajasthan. Okay, so that is called exclusivity. Exclusive rights are given to a particular licensee that uh, so uh, so that no other party, no third party can sell my product into Rajasthan except you. All right. So there are two types of agreement: exclusive agreement and non-exclusive agreement. That I'll write in the chat box. Exclusive. And non- okay. So exclusive agreement is it excludes all other from using the trademark and including the owner of the trademark. So let's say I am the owner of the trademark and you are licensee, and we enter into an exclusive licensing agreement. Now we have agreed that you and only you will be able to sell the sell my product into Rajasthan. Now, exclusive agreements mean now even I cannot sell. I, as a owner, cannot sell my product into the territory of Rajasthan, and only that particular licensee will be able to sell. Okay, that is exclusive agreement. So it excludes all others, including the owner himself. Okay. Non-exclusive is just opposite. The owner can license the trademark, the use of the trademark to more than one person. Okay, so that is non-exclusive. So licensing to only one person and only that person will use the trademark, that is exclusive, and licensing to more than one person, that is non-exclusive. Okay, I hope that's clear. So you need to remember into this exclusivity clause that ownership doesn't change, only the rights change. The rights are delegated. Okay, so that is that. So if there is exclusive agreement, the royalty charges or the consideration is also higher. Okay, so let's say I am restricting myself as the owner to sell my product into Rajasthan because I am giving you an exclusive license. So what I'll do is I'll charge extra from you. I'll charge higher from you because now I'll be restricted now. So I'll charge higher amount. If let's suppose that I'm giving you exclusive agreement to sell my product in in all over India. Okay. So now my royalty charge again will increase. It will be higher now because I am restricting all others plus myself to sell my product, and I'm giving you the rights to sell. So I'll charge, obviously I'll charge extra from you. I'll charge higher amount from you. Okay. So that is a point of exclusive agreement. So the second clause is geographical or territorial restriction. So again, the same example that if I put this clause in our agreement in between you and me, that you will only sell or you will only deal my product within this particular territory, then that is geographical restriction. Okay. So there should be a, then the third point is in the agreement, there should be a commercial understanding between the parties. Okay, commercial understanding here means, let's say that I agree that I'll give you a license to sell my products on the condition that you share 20% of revenue with me every month. All right. So that is how franchising is done, right? So if Pantaloons come to your city and you take the license of Pantaloons to open a store of Pantaloons in your city, then what you'll have to do, you'll have to share a lump sum or a percentage of your revenue to the Pantaloons. That's why he's giving you the license to open their store in your city. All right. So that is a commercial understanding between me and Pantaloons, right? That Pantaloon has agreed to share this percentage of profits, and rest of the profits will be kept by me because I'm doing the business. Okay. So that is commercial understanding. The third one is training. Sorry, this is the fourth point, training. So training is given by the person, by the owner or the licensor. Okay. So there are several kinds of products, businesses that are going on. So let's say Starbucks. If if I am the owner of Starbucks and I'm giving you the license to open a Starbucks store in your city, and if I don't give you the training how to make certain products, how to what ingredients are to be mixed, what quality of products are to be used. So how will you maintain the quality? Okay, I cannot expect you to maintain the quality if I'm not giving you the training. So training is a important part of the licensing agreement. You have to remember this. You have to stress upon it that training should be given to the licensee so that the expected quality could be maintained. Okay. So the fifth one is variation of products is permitted or not. One second. Give me a second, please. Yeah, sorry. So the fifth thing that you need to remember is if the variation of the product is permitted or not. What do you mean by variation? So let's take an example. I am a shoe manufacturer. Okay. I've made 5 designs of that shoes and I want to license it to you that like you have come to me for the license to get license or authorization from me to sell my shoes into your city. Okay. So now you as a licensee want to expand the designs from 5 to let's say 7. Okay. You want to add 2 more designs to my shoes. But the licensing agreement doesn't say so. Like say so. Okay. That's a problem with me with Shine Sa, so don't mind it. So yeah, if the licensing agreement doesn't state that you can expand the variation of my shoes, then you cannot do that. Otherwise, that will be a breach of contract. Okay, breach of licensing agreement. So you need to remember that if there could be a possibility of variation of your product or service, you can expand or contract the products or services in the future as a licensee, then you need to first take permission or authorization from the licensor, and that could be altered into the licensing agreement as per the need. Okay, is that clear? Are these points clear? These are the points you need to remember while making a licensing agreement. Are these clear? Any doubt, please ask. Okay, if you have any doubt, you can put it into the chat box. We'll proceed. So now we'll talk about what does the licensing agreement contains. Okay, so there should be grant of rights. Grant of rights means if the agreement is exclusive, non-exclusive, or there could be a sub license, so that should be mentioned in the licensing agreement. Okay, so sub license here means license to own subsidiary. So let's say non-veg store. So if they want, if as a distributor they want to, they want to sell, so they are operating all over India, right? So they must be having subsidiaries who are working for them. For that, they also have to authorize, they have to take authorization from the owner, from Puma or Nike, to authorize their subsidiaries to deal into that trademark. Okay, with respect to that trademark, they have to obtain license that our subsidiaries also want to like distribute your products, right? So in that case, a sub licensing clause is entered into the agreement. Okay. So the second one is consideration. How much payment will the licensor get? That is necessary to mention in the clause of the licensing agreement. Okay. Then quality control. How will the licensor check or inspect that the quality of his product or services is being maintained by the licensee? That has to be put into the licensing agreement. Okay, so the licensor has right to inspect or call for samples from the licensee of his products. Okay, that's how the quality control can be done. So again, I'm repeating that ownership is not transferred, only the limited rights are transferred. Okay, so that you need to keep in mind. Then force majeure is act of God. So you see that there are some things, if if a licensee breaks some condition or term of the agreement, then he has to like pay the price of it. Okay, but there are some things which are beyond the control of a licensee, which are like for example COVID. If a COVID has come, everyone's business was shut. Now the licensee cannot, the licensor cannot say to the licensee that you have stopped making revenues and you have stopped sharing revenues, because nobody's business was working at that point of time. So that is a force majeure clause which has to be entered into licensing agreement, that what if a circumstance arises which is beyond my control. Okay, so in that case, what, how will we deal uh, with it? That is a clause of force majeure. Okay, force majeure, I'll write down in the chat box. Act of God beyond the control of life. Okay, I've written it in the chat box. Okay, so the other clause which you need to stress upon is dispute resolution. Dispute resolution means how will we approach if any dispute arises? How will we resolve it? So if you want to go into arbitration, you need to put a arbitration clause into the agreement that will, if there is a dispute in the future, then we'll go into the arbitration. Or let's say we'll approach district court, then you need to put the forum's name, that if there is a dispute in the future, we'll approach to this particular forum for dispute resolution. Okay, so that is dispute resolution clause. Then representation and warranties. Okay, so representations are with respect to past and warranties are with respect to future. So with respect to past, representation means the licensor will give such evidence or representation that I am the owner of this product or service. Okay, that I am not giving any false representation or misrepresentation. Okay, so that is the meaning of representation, that owner has to give proof that into the, and it has to be mentioned, written down into the licensing agreement, that I am the owner of this particular product or service, and it has to be verified by the owner. Okay, now warranties mean for the future the licensee has to promise to manufacture the product as per the licensor's term. Now if I am the licensor and you are the licensee, then you have to give the warranty that you will manufacture my products as per my terms. Okay, that is warranty. So if you vary from the terms, you need to notify me. We need to alter the licensing agreements and the terms. Okay, so that is warranties. Now, the last vital clause that you need to remember into licensing agreement is recitals. Okay, I'll write down recitals written in the chat box. So recitals are the starting or the beginning part of the licensing agreement. Okay, I'm dealing it into the end, but it is the starting or beginning of the agreement, wherein you introduce both the parties and also you mention the purpose of the agreement in the beginning of the agreement. Okay, so I am so and so, son of so and so, daughter of so and I reside at this, and I deal in the product shoes, which falls under the class 25 of niche classification. And then this particular person is the licensee. And so all the basic first portion, the first paragraph of the basically the licensing agreement is called recitals. So that needs to be put very cautiously. Okay, so if you do something gadbad into the recitals, you do something wrong, then you like everything goes into vain. Okay, so that is all about licensing agreement. Now we'll switch to assignment fast and we'll complete it into another 10 minutes. Okay. So I've already told you assignment. So if there is any question regarding license, you did not understand anything, put it into the WhatsApp group. I'll deal with it there. Okay, I'll type it. Okay, what is assignment? Assignment is the transfer of ownership. Okay, so uh, the act says, so you refer to section 45. Section 45, right? Section 45 of Indian Act. Okay, assignment. So, yeah, under assignment, ownership could be transferred with or without goodwill. So I'll come to with or without goodwill later. So first thing, that assignment has to be compulsorily recorded with the registry, trademark registry. Okay. So within 6 months of the assignment, so from the date on which the assignment is made till 6 months from that date, you need to register, you need to record it with the registry. Okay. So even if it is registered trademark or unregistered trademark, in both the cases, you need to register it with the registry of trademarks. Okay. So there could be a query that if the mark is itself unregistered, how will we why there is need to register the assignment? Because the law says so. That is the answer. Because the law says so that if there is an assignment of registered or an unregistered mark, the assignment should be recorded within 6 months. So 6 months period is also necessary to remember. Okay. So there are two types of assignment. One is complete assignment. The other one is partial assignment. Okay. So complete assignment is complete and absolute rights and goodwill to the other party. That is complete assignment. Like for example, I am the trademark owner and I have given all my rights to you. I have assigned my trademark, I have given my permission, I have made you the assignee, sorry. I'm the signer and I've made you the assignee. And now you can use the trademark as you want. That is complete assignment. Okay. And the partial assignment is the assigner transfers limited right to the assignee. Okay. So, for example, I am manufacturing apparel, shoes, and cosmetics, but I assign you rights. Samya, you can leave. If you have other class, you can see the recording later. And what was I telling? Partial assignment. Yeah. So example is, for example, I'm manufacturing shoes and then apparel and then cosmetics. Then you as a assignee, I give you only the partial right to sell cosmetics, not apparels, not shoes. Okay. So I assign you my rights respect to cosmetics only. Now this is partial assignment, wherein you cannot deal into apparels or shoes. You can only deal into cosmetics. Okay. That is partial assignment. So it could be for a limited period also, or limited goods also. So that is partial assignment. But in general practice, people do complete assignment. It's very rare that someone does partial assignment. Okay. So there are two types, because there are two types exist. That's why I'm telling you. But then in general practice, complete assignment occurs. So now coming to assignment with goodwill and assignment without goodwill. So with goodwill is where in general practice also the assignment is made with goodwill only. So what is a goodwill? Anybody? What do you mean by goodwill? Can anybody explain what is goodwill?
Reputation.
Okay, yes. Anybody else wants to add something? No. Except Pooja and Soumya, is anybody else listening? Say yes into the chat box, please.
Yes, ma'am.
Okay, Akriti. Thank you. Thank you, Basudev. Okay, if 4 5 people are listening, okay, Priya, Rajesh. All right. So, okay, I understood. So, we are about to end this class. So there are only 2 points left, wherein I'll explain what is assignment with goodwill and assignment without goodwill, and then the documents which are used to record assignment. So these 2 points are left. After that, this class will be closed, and you can put up your doubts into the WhatsApp chat group. Okay. So assignment with goodwill. Goodwill is the reputation or the name which is built by the business in a long period of time, right? The trust which is built up into the minds of consumer, that is goodwill. So assignment with goodwill means that the right and value of the trademark associated is transferred, and the person acquiring the trademark can use the same for selling other products as well. Okay. So Bhagyashree is saying goodwill means friendly, cooperative, good name. Okay. Okay. Not having any bad name. Okay. That can be our, this is an, absolutely, it's an aspect of goodwill. This is the hard earned trust. Okay. So it is the good name, obviously, but it is earned not like in a day or so. It's like it is earned from a long duration of time, over a period of time, and it is the reputation of company through which the, like, the consumer, if the consumer identifies a good with a particular brand name, and that is what attracts a consumer, we can say that this particular brand name has a goodwill. Okay. And for example, Colgate. Now, you know and you trust that Colgate will have maintained their quality, and you use this particular toothpaste from since your childhood. So you will never change this particular toothpaste. So that is what that Colgate has earned, your trust. So that is how a brand builds its goodwill or its reputation. Okay. So now when I assign my trademark to you, I assign my goodwill also to you. Now, when you uh, deal with the products, okay, my goodwill will carry on. My goodwill will be attached to those products. And if, let's say, Colgate assigns all of their rights to me, okay, now I'll carry the name of Colgate and the goodwill associated with that particular product. And also, if I expand the type of product, let's say with toothpaste, I start selling toothbrush of Colgate. Okay. Now, even the toothbrush will carry the goodwill which has been maintained by the Colgate toothpaste. Right. So that is assignment with goodwill. Now, what is assignment without goodwill? Without goodwill, there is a restriction. Okay. So there are restrictions on the rights limiting the new owner from using the brand uh, on the products that original owner uh, or the signer is already in. Okay. So let's say just to be very precise, you use my name, but you don't deal in the products with which I am producing. Okay, so you can use that brand name Colgate, but don't manufacture toothpaste or toothbrush. That is assignment without goodwill. Now, I have restricted my goodwill to myself and I have assigned you just the trademark. But you have to deal with, you can deal with any other product except toothpaste. Okay. So that is the difference between assignment with goodwill and without goodwill. In with goodwill, I assigned you all my rights absolutely, and I assign you my products as well. But in without goodwill, I have just assigned you my trademark, but not my products. You cannot deal in my products. Okay. You have to change the products. So you sell Colgate named shoes. I don't have a problem. Okay. I've assigned you my rights restricted only till use of trademark and not the products. So you can sell shoes name of Colgate. That is not a problem. Okay. But if you sell uh, Colgate named toothpaste, then I have a problem because then I have to transfer. I have to assign like I have to assign my products with goodwill. Okay, trademark with goodwill. So that's how it works. So basically, in general practice, everybody assigns with goodwill only because why will the assignee will take your trademark? So nobody will purchase it, right? It will be like starting a new business altogether. So assignee is taking your trademark for your goodwill. Okay, so that he can earn upon that goodwill. He can do business. He'll have a setup. Already have a market. He'll already have a trusted clientele, and on that he will do his business. So that's how the signing works. Now the last portion, what are the documents you need to need? So there must be a deed of assignment. Okay, so in that deed, both parties must sign. Their details must be mentioned, both sign, and it should be notarized, and consideration also has to be mentioned in that deed. So everything related to the assignment, all the details has to be mentioned in the deed of assignment. Okay, the second one is statement of case. Statement of case as per section 40 clause 2, read with rule 77. It says that how assignee becomes the proprietor of trademark. So it is basically, statement of case is basically a declaration where it is stated that the assignee has now become the proprietor of the trademark. All the rights has been assigned to the assignee. Okay. So the third document needed is an affidavit of no legal proceeding pending with respect to trademark. Okay. Affidavit needs to say that my trademark, as a signer, I will say that my trademark has no pending legal proceeding against the mark. Okay. So there is no legal proceeding which is pending in the court of law. So for that, I need to file a affidavit. The fourth one is power of attorney. Obviously, there should be a power of attorney authorizing the advocate, the attorney. Okay. Now, if there is an Indian company who is transferring the trademark to someone, then there should be board resolution. Okay. So all the directors and the members of the board, they need to pass a board resolution saying that, okay, we are agreed, we agree that this particular trademark of the company could be transferred or assigned to someone. Okay, so that should be their board resolution. Then for registered trademark, TMP form, I'll write in the chat box. TMP form for registered trademark. Okay, and TMM form for unregistered trademark. So form TMP has to be filed for registered trademark and TMM has to be filed for unregistered mark for assignment purpose. Okay. So that has to be filed in the trademark registry, and the fee is 9,000. 9,000 for online. Okay. So if you want to assign a product or service to someone, you need to file these forms as per your trademark, and you have to file 9,000 as fee. Okay. So that is that. And your licensing and assignment portion is complete. Now, if you have any doubts, you can ask me here. If you have small doubts, I can clear upon it. If you didn't understand anything, want me to repeat, you can also tell me that. Otherwise, we'll end the class in another 2 minutes.
Ma'am, can you just repeat the section for statement of case?
Statement of case. Yes. Section 40, clause 2, read with rule 77. I'll write it down in the chat box. Wait. Section 40, clause 2. I've written it in the chat box, Pooja. Okay. Anything else? So, in the Trademark Act, always please, it's a request, please refer to the rules as well as the sections, because sections are the substantial part, and they don't tell you what is the procedure. So if you want to practice into the trademark area, you need to like be thorough with the 2017 rules. Okay. Without it, you won't be able to understand what forms are to be used. In the schedule of the rules, there are several forms. You can also go through the headings of those forms. I've already explained all the forms in the previous classes. But again, once if you don't look into yourself, then you won't be just, I cannot spoon feed you, right? So you won't be able to understand if you don't look at yourself. So please go through the trademark rules 2017 and all the rules which are important that I told you in the previous class. Go through the recording and note down what are the important rules, and just read, just take a look once. Okay. So that you understand what are the basic particulars that you need to remember while filing a trademark application. Okay, and also I'm always here. If you have any doubt, even after this certificate course, you can always approach me through WhatsApp. Okay, you have my number. If you practice into the area, you can approach me, and we'll discuss. If there is any doubt, if I don't know anything, I can again ask my seniors and let you know. So that is not a problem. Okay, then, Shweta, we'll end the class. If you have any doubts, please put it up into. Yes, Priya, if you are there in the WhatsApp group, I'll just text through that my chat into the group, and you can text me if you have any query. You can send it into the group. You can send it to my personal chat also if you have any query, and we'll discuss.